You came to the United Kingdom legally. You followed every rule. You paid your taxes. You renewed your visa on time. You built your life here, and you were counting down the years to the moment you could finally apply for indefinite leave to remain and call this country your permanent home. But right now, the UK government is preparing to pull the rug from under your feet. The 5-year ILR route that you planned your entire future around could be gone.
And the replacement they are proposing does not just affect people arriving tomorrow. It is designed to affect people already living in the UK today. Over 350,000 migrants are in the firing line, and the clock is already ticking.
After all this time?
In May 2025, the UK Home Office published the document that sent shockwaves through every immigrant community in Britain. The Immigration White Paper, titled Restoring Control over the Immigration System, proposed the most dramatic overhaul of the UK settlement system in decades. At its centre was one devastating proposal. The standard qualifying period for indefinite leave to remain, commonly known as ILR, would double from 5 years to 10 years for most migrants.
That single change, if fully implemented, means that someone who arrived in the UK on a skilled worker visa in 2022, expecting to apply for permanent settlement in 2027, could now be waiting until 2032. Someone who arrived in 2023 could be waiting until 2033. And the proposal does not stop at 10 years for everyone. Depending on your visa category, your skill level, your salary, and your conduct record, the wait could stretch to 15 years, 20 years, or in extreme cases, 30 years.
The Home Secretary confirmed that immigration rules would begin changing from April 2026. This is not a distant threat. It is happening now. And if you are on a path to settlement in the UK, you need to understand exactly what is being proposed, who it affects, what exceptions exist, and what you can do about it before the rules lock in permanently.
The first thing you need to understand is what the current ILR system actually provides and why so many people have built their entire life plans around the 5-year route. Under the current rules, most migrants on work visas, family visas, and several other routes become eligible to apply for indefinite leave to remain after 5 continuous years of lawful residence in the UK. ILR is the closest status to British citizenship without being citizenship itself. It removes all immigration restrictions. It grants the right to work in any job without sponsorship. It grants access to most public benefits and social housing. It removes the visa renewal cycle that costs hundreds and sometimes thousands of pounds every 2.5 to 3 years. And it opens the door to British citizenship after just 1 more year. For the roughly 2.2 million people currently on a route to settlement in the UK, ILR has not just been a legal status. It has been a promise, a destination, the finish line they were running toward. The second critical point is understanding the sheer scale of what is now being proposed and why the government says it wants to change the system. The Migration Observatory at the University of Oxford has calculated that the Home Office projects 1.6 million people would receive ILR between 2026 and 2030 under the current rules. That is an enormous number, driven largely by the record levels of migration that occurred between 2021 and 2024. During that period, hundreds of thousands of people arrived on health and care worker visas, skilled worker visas, student visas, and family visas. The government's concern, stated explicitly in its consultation document, is that this wave of settlement will also bring a wave of access to welfare entitlements, social housing, and public benefits that ILR automatically unlocks. The Home Secretary has publicly raised concerns about the fiscal cost to the country. The government's position, in plain terms, is that settlement must be earned.
not assumed after a fixed number of years.
The third point is the most alarming for the hundreds of thousands of people already living and working in the UK right now. The proposed changes are explicitly designed to be retrospective. This means they would not just apply to new arrivals who come to the UK after the rules change, they would apply to people already here today who have not yet been granted ILR.
The government's consultation document stated clearly that those who were due to reach settlement in the coming months and years would be subject to the new requirements as soon as the immigration rules change. The Home Secretary told Parliament that the rules would begin changing from April 2026. This means a nurse who arrived in 2021 expecting to apply for ILR in 2026 may find themselves subject to a completely different system than the one they signed up for.
A care worker who left their family in the Philippines to build a life in Britain, counting down to the 5-year mark, may now discover the goalposts have moved by 5 additional years. The retrospective nature of this policy is what has provoked the most intense anger among migrants, immigration lawyers, and civil society organizations across the UK.
The fourth point covers what the new system would actually look like under the proposed earned settlement framework. The government's consultation document, published in November 2025, set out a tiered system with different qualifying periods depending on the applicant's visa route, skill level, salary, and contributions to the UK. For most applicants, the baseline qualifying period would be 10 years. However, this 10-year baseline can be reduced for positive contributions. High earners and people working in strategically important sectors could potentially qualify after as few as 6 years. Migrants in highly skilled roles at RQF level 6 and above, equivalent to a university degree level on the skilled worker visa, could qualify after 10 years under the standard route. Migrants in medium-skilled roles below RQF level 6, including many roles that were formerly on the shortage occupation list, could face a 15-year qualifying period. Refugees granted asylum in the UK under the standard asylum route would face a baseline wait of 20 years, and migrants who arrived through illegal entry or who overstayed their visa at any point could face a waiting period of up to 30 years. The 10-year-long residence route, which currently allows migrants who have accumulated a decade of lawful and unlawful time in the UK to apply for settlement, is proposed to be abolished entirely. The fifth point covers the groups who have been given specific protections and exemptions from the harshest changes. Family members of British citizens, meaning people who hold a spouse visa, partner visa, or other family visa sponsored by a British national, would continue to be eligible for settlement after 5 years. This is an important protection that affects an estimated 352,000 people. Holders of the BNO visa, the route specifically created for Hong Kong British National Overseas Passport holders, would also continue to qualify for settlement after 5 years. Migrants on the Innovator Founder Visa and Global Talent Visa would retain their accelerated 3-year route to settlement. These exemptions are significant, but they leave the vast majority of work visa holders, student visa holders converting to work routes, and many family members sponsored by non-British settled persons facing the full impact of the new rules. The sixth point concerns the new minimum requirements that would apply to all applicants regardless of their visa route. Even people who remain eligible for the 5-year route under the exemptions would face tougher minimum standards to actually qualify. The English language requirement is being raised from B1 to B2 level under the Common European Framework of Reference for Languages. B1 is the standard currently required and represents an intermediate level of English. B2 is significantly harder and represents an upper intermediate level roughly equivalent to an A-level qualification in English. Many migrants who have lived and worked successfully in the UK for years may struggle to reach B2 without formal preparation and testing.
I'm proud to confirm my
This
global talent
B2
visa and
requirement
3-year
for
settlement
new
route
visa
remain intact.
applicants under
This
the
is a great
skilled worker,
achievement.
scale-up,
This
and
can't be
high-potential
right.
individual routes
Retrospective,
already came into force on 8 January 2026. Additionally, applicants would need to demonstrate that they have earned a minimum taxable income of £12,570 per year for at least 3 to 5 years prior to applying. This is intended to show economic contribution and reduce reliance on public funds. The seventh and most immediately actionable point is what anyone currently on a path to settlement should do right now. If you are within touching distance of 5 years of lawful continuous residence in the UK, the most urgent advice from immigration lawyers is to calculate your exact eligibility date and speak to a qualified immigration solicitor immediately. If you are close enough to apply before the new rules are locked in through formal changes to the immigration rules, applying as early as possible could be critical. The Home Secretary confirmed that changes to the immigration rules would begin in April 2026. However, the final shape of the rules depends on decisions taken following the public consultation that closed on 12 February 2026, and there may still be transitional arrangements for some groups. The petition calling on the government to keep the 5-year ILR route had already gathered over 241,000 signatures at the time of publication, and a Westminster Hall debate was held on 2nd February 2026. Public pressure is intense. But public pressure, however powerful, is not a substitute for proper legal advice tailored to your individual circumstances. What is happening to the UK ILR system in 2026 is not just a policy change. For hundreds of thousands of people, it is a life change. People who planned their families, their finances, their careers, and their futures around a 5-year promise are now being told that promise may not be honored. That is not just frustrating, it is frightening. And the worst thing anyone in this situation can do right now is wait and hope it all works out. The time to act, to get advice, to understand your individual position, and to explore every option available to you is now. If this video helped you understand what is happening and what it means for you personally, share it with every person in your network who is on a UK visa. The people who need this information most are the ones who are not yet looking for it. Leave your specific questions in the comments. Subscribe to this channel for every update as the rules continue to evolve. We will be here with the facts, the clarity, and the guidance you need as this policy develops through 2026 and beyond.